Thank you, Mr. Chair. Let me thank the witnesses for their presence here today, and certainly let me thank all of the victims and their families for your presence here today. And certainly you've been subjected to something that no American should have to deal with in terms of the asbestos exposure, and now this fight to ensure that you are justly compensated. Let me start with Mr. Scarcella. You're here today in support of the FACT Act, correct?
Correct.
And as far as you know, the victims of asbestos, those who've been exposed unjustly to asbestos and mesothelioma, other forms of cancer, they don't support the FACT Act, correct?
That's what's been told to me today.
And as you understand it, the trusts don't support the FACT Act, correct?
Correct.
So other than the asbestos industrial complex, who, in terms of interested stakeholders, actually supports the FACT Act?
I can't speak for who else supports the FACT Act. I know I support it.
And why do you support it, sir?
Why do I support it? Because I've had a unique perspective of working both in the trust and tort system. I know how both processes work, and I know how damaging the premature depletion of trust assets can be. Just last April, the UNR Asbestos Trust, which was one of the first asbestos trusts that was confirmed in the early 1990s, filed a motion with its bankruptcy court requesting early termination by the year 2019 because it's simply running out of money. And at the heart of their request was a claim that they received more claims and paid more claims than they expected.
Right. So you don't believe that there's any evidence of fraud as it relates to the administration of these trusts, correct?
No, I don't think the management of these trusts is acting in any fraudulent way. I think it really comes down to a system that is set up in a way that could allow and incentivize bad actors to infect it. It's not to say that all plaintiff attorneys don't act appropriately. Certainly, I think the plaintiffs all do. They put a lot of trust in their counsel. But it is a system that is set up to allow bad actors to take advantage of certain loopholes.
Right, but we're putting the cart before the horse because we're here to try and correct a problem that doesn't exist. There's no evidence, you've just acknowledged, of fraud in the administration of the trust. Do you think there's evidence of waste or abuse?
Well, no, I believe, at least my understanding of your question was that, was there fraud being conducted at the management level of the trust?
Right.
I am concerned that there may be inconsistent or potentially fraudulent claiming behavior being conducted by bad actors such as plaintiff attorneys who file with the trust. That's my concern. You have to keep in mind, as Mr. Very put correctly in his direct testimony today, these trusts operate in vacuums. There's over 50 trusts controlling collectively almost $30 billion in assets, and they don't really interact with one another at the claim resolution level.
Sir, let me ask you a question there. Are you familiar with the 2011 GAO report that
Very much
studied the administration of these trusts? And am I correct that it looked at, I believe, a 23-year period with respect to these trusts, correct?
I don't know that, but I'll take that to be accurate.
23 years, from 1988 to 2010. It analyzed about 3.3 million claims, correct?
Again, I'll take your word for it.
Over $17 billion in payouts, correct?
Again, I'll take your word for it.
And not a scintilla of evidence that so-called plaintiff attorney bad actors had actually managed to pull off a fraud resulting in an inaccurate payment, correct? That's what the GAO study concluded.
Yes, and I addressed that in my testimony. The fact that there was no fraud self-reported by these trusts that they interviewed. It was self-reported.
Thanks for raising that.
Is not an indication of a lack of fraud, but more a serious indication of the lack of ability for these trusts to actually audit properly.
Sir, let me reclaim my time, only because the chairman has been particularly rigid, as I understand it, with respect to the 5-minute rule. The GAO report, which was requested by then Republican Chairman Lamar Alexander Smith, never contested the GAO report in terms of its methodology. It used a whole host of publicly available documents, interviewed trust officials, court officials, professors, used the RAND study, And it also had subpoena power if it determined that it wasn't getting accurate information. And so I think the reality is, again, we're trying to solve a problem with the FACT Act that simply doesn't exist. I yield back.
Thank you.